hearing of July 21st, 2020 for the City of Ridgefield. My name is Joe Turner. I'm the city's hearings examiner. This online hearing is reasonable and necessary at this time to comply with the state's social distancing order, maintain public health and safety, and meet state-imposed deadlines for decisions on land use applications. I start by saying I am not a city employee. I am licensed as an attorney and trained as a planner. I serve under contract to the City Council. I say that so you know you're getting a somewhat independent review of the application before me tonight. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in the City of Ridgefield. In making those decisions, I am required to apply the city's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with the Board of Commissioners, City Council, wrong jurisdiction, City Council and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. So any changes would not affect this application. As a hearings examiner, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. However, you have the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'm going to start with an overview of the hearing procedures generally, and then I'm going to attempt to address some of the technical issues with this online hearing that may or may not occur. So the procedure will follow. I'll start by asking staff to briefly summarize their staff report, copies of which are available online. Then the applicant will have an opportunity to respond to the staff report and summarize their proposal. Then, given I don't know who is interested in which side of this application, I will just go through the list and ask one at a time anybody if anybody wants to testify, and we'll go through that list. Once everyone who wants to testify has had an opportunity to do so, I will give staff and the applicant an opportunity to respond to the testimony that was offered. If that response includes any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria which are set out in the staff report. However, it's also important that you make your best case to me. My decisions are final for purposes of the city. My decision may be appealed to Superior Court, but the court generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the hearing, close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me. If you feel you need more time to prepare, you can ask me to hold the record open or to continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. Because this is an online hearing and we've had in other jurisdictions had issues with connectivity and other things, I will hold the record open for a week after this hearing regardless, to allow the public to submit additional written testimony in the event that you're unable to appear personally. I'll hold it open for an additional week for the applicant to respond and submit a final written argument, but the applicant can waive that second week if they choose at any time after the end of the first week. But if anybody wants me to hold the record open or continue the hearing beyond the 1 week open record period I've just discussed, you need to make that request before the close of the hearing today. When you testify, please state your name and your full mailing address, although staff, I understand that. We'll get to that in a second, but at this point, do that. Also, if you come back to testify, if you've testified and then we come back to you, please state your name again so we know who's talking. There are some names, some phone numbers listed on the screen here, so it's easier if you state your name so we know exactly who's talking for the record. There is no arbitrary limit to the length of time you can testify, but testimony should be relevant to the approval criteria. And please don't repeat testimony offered by yourself or earlier witnesses. I take good notes and I can review the recording of the hearing if necessary. As far as technical issues, I understand that staff will mute all of the microphones. Yep, everybody's muted right now, just so we don't get feedback or other background noise. When it's your opportunity to testify, staff will unmute your microphone. You'll have an opportunity. I'll ask you to state your name and your full mailing address if it's the first time you're testifying, or just your name if you're coming back again. And if you represent someone else, please say so. As I said, when it's time for public testimony, I'll just go through the list and ask one at a time if you want to testify. Some people who've phoned in are identified by phone number rather than by name, so I'll just recite your phone number. Some don't list a full name, just a first name. So I apologize for any issues there. In this way, we're going to try and make sure everyone has a full and fair opportunity to testify. But as I noted, I will also hold the record open for an additional week after today to make sure anyone can submit additional written testimony and evidence. Ms. Lust, I understand you wanted to go through and the participants create a attendance roster. Is that correct?
You know what? I think I have put together a complete list already.
Right.
So I don't need any more on that. I will say for when people are, when it's your time to talk, if you could unmute yourselves, that would be helpful. I don't think I can actually do it for you. But if you hover on your screen, there should be a toolbar that shows a little microphone symbol that you can mute and unmute.
Yeah, it should be down at the bottom, the center of the screen. Okay, that's where I'm seeing it. Okay, and Mr. Eisman, are you presenting this one?
Yes, I am. Thank you, Mr. Examiner. Mr. Examiner, members of the public and staff who are here, my name is Eric Eisemann, spelled E-I-S-E-M-A-N-N. I'm the consulting planner on this project representing the city of Ridgefield. My work mailing address is E Squared Land Use Planning, LLC, 215 West 4th Street, Suite 201, Vancouver, Washington, 98660. I've got about 7 minutes of notes that I'll just kind of recite to you, and then after that I will turn it over to City Engineer Brenda Howell for any comments that she might offer. So this is a proposal to subdivide 23 acres into 40 detached single-family residences using the provisions of the Ridgefield Development Code, the RDC, for subdivisions, PUD, and critical areas-based zoning. The site is zoned residential, RLD4, low density residential. Approximately 13 acres of the 23 acres will be reserved for open space. Thank you very much, Claire. The project site is 3 parcels located off of South Hillhurst Road. One site is addressed 1108 South Hillhurst. The other is addressed 1104 South Hillhurst, and the third is not addressed. So current conditions on the site, there's one residential dwelling with access onto the Hillhurst Road, and that site includes a manufactured home, a garage, and outbuilding. Most of the developable area is a grassy field. However, much of the wooded area that's associated with the G Creek riparian habitat and steep slopes, as you can see on the site plan, is off to the east side. The site is bordered to the southwest by South Hillhurst Road and to the east by G Creek. Low-density residential lands border the site to the north and south. And South 19th Place, which comes in from the top of the site plan, abuts the property to the north but will not be connected through. However, there will be a trail access, and the lack of connectivity for the street is due to steep slopes there. Speaking of slopes,
that shows as South 9th Way on the plat that's before me.
Sorry, my mistake. Thank you very much.
Thank you. So 9th Way is correct.
Shall I go on?
Is 9th Way the correct street?
I believe it is.
Okay, Just wanted to check. Thank you. Go ahead.
I'll verify that for you. Slopes generally range from 0 to 10% along Hillhurst Road, and they become increasingly steep as you head towards the east, towards the G Creek area, and can be as much as 40% in some areas. There is a wetland on site, which is in the G Creek riparian area. It's about 0.91 acres, and it requires a 100-foot buffer. The G Creek itself is a type F fish-bearing stream. Flows through the eastern portion of the site outside of the development area, except for the trail, and it requires a 150-foot buffer. There are two unnamed type N seasonal tributaries to G Creek that run from the west to the east that are in this by this proposal as well. The applicant did conduct an archaeological predetermination and identified several potential resources coordinated with the Department of Archaeology and Historic Preservation. That information is logged and registered with the state. However, the applicant's archaeologist, a qualified professional, concluded that properties are not eligible for listing on the National Register of Historic Places, and therefore no further historic analysis is required. This is, as I say, a PUD. As you can see on the site plan, there are multiple tracks. Tracks B, C, D, and E will create open space for passive and active recreation, including a trail along the southern tier of lots, along from 2 to 13, and also a trail that will head up towards the north and also towards G Creek Trail itself. There is also a tract A, which is in the lower southwest corner of the site, which is a tract set aside for a regional gas line as the code requires. Homeowners Association will maintain and be responsible for all of the tracks within the project area. As I said, this is a PUD, and through the PUD process, you may reduce lots to no less than 65% of the minimum lot area in the underlying zone, which is 10,890 square feet in the RLD4 zone. So the smallest lot could be 7,078.5 square feet. The smallest lot in the project is 7,100 square feet. So all of the lots exceed the minimum lot size through the PUD process. Regarding public comment, the city provided SEPA notice and public comment on May 14th, 2020. We did receive 2 comments. The first was in the package that was delivered to the hearings examiner, and that was a SEPA comment letter from the Washington Department of Ecology. They had 2 comments one relating to water quality and one to solid waste management, but they also had a recommendation to, quote, relocate proposed lots 13 and 14 to tract B, such that the stormwater facility can be moved slightly west to the space where lots 13 and 14 are currently proposed, end of quote. The applicant's engineer, Mr. Stonix, evaluated that request and responded by email to the city and suggested that the steep slopes in tract B would not support the stormwater facility consistent with Ecology's recommendation. Staff concurs with the applicant's engineer's assessment.
Mr.
Today,
on that issue, I had a question.
Yes.
I understood that Ecology wanted the applicant to move lots 13 and 14 into tract B and then shift the stormwater facility west, so that the topography issues in tract B don't seem to apply unless it prevents those lots from occurring there.
I'm reading from Ecology's letter. It was to relocate proposed lots 13 and 14, which are in the southeast corner, to tract B. Right. And then that the storm. Sorry.
I thought you said that the issue raised by the applicant was that tract B, the topography can't support the stormwater facility in tract B. Which
if that's a technical question relating to engineering, perhaps you'd want to ask Mr. Stonix when he comes on board.
Okay, I'm just, if they're shifting, I thought they were shifting 13 and 14 to tract. The Ecology was requesting that they shift 13 and 14 to tract B.
Yes.
And stormwater facility to the west where 13 and 14 are.
Which is a steep slope area. If I misspoke, I apologize for that.
Okay. I'll ask the applicant to expand on the issue there. That was my question.
All right. Thank you. Shall I go on?
Yeah, please.
All right. This afternoon, we did receive an email from Cindy Bachstatter, which hopefully has been distributed to the hearings examiner. The email was regarding wildlife and bird habitat along the G Creek corridor, and she questioned whether an EIS should be required. Staff believes that the city's SEPA DNS threshold determination was proper because it was based upon the applicant's critical areas analysis, which was done by ELS, Environmental Land Services, a qualified professional in the field, and also because we are proposing conditions of approval that the applicant would have to meet related to the city's critical area code, which is based on best available science. And furthermore, during the SEPA process and public comment process, no agency, state or federal, commented on the need for an environmental impact statement. Regarding development code compliance, the staff report analyzed the proposal based against the Ridgefield Development Code applicable criteria and concluded that the proposal as suggested or as staff has suggested with conditions of approval can meet the city's applicable regulations for PUD subdivision in critical areas. There is one issue in the development code that we have not, I believe, brought before you before, and that relates to 18-840-040, the Ridgefield Heritage Tree Register. In the staff report, we identify that an Acer palmatum, a Japanese maple, is on the site for 1104 South Hillhurst. That tree is listed on the city's Heritage Tree Register, and the city code requires that that tree shall be protected, quote, unless the city council determines that the tree may be removed based on the removal criteria for heritage trees, end of quote. That relevant section then in 18-840-050A goes on to state that a heritage tree may not be cut or removed without obtaining approval from the city council upon a demonstration of compliance with one or more of the removal criteria. So we have proposed a condition of approval that says that prior to the site disturbance of 1104 South Hillhurst lot, the applicant shall, consistent with the code, either provide the community development director with a tree preservation plan, secure the variance to the standards as provided in 18-840-040C, or secure city council approval to remove the tree as provided in 18-840. So with that, I think we've identified in section A, under the conditions of approval in sections A1 through 39, a list of planning related conditions which we believe are consistent with the code and which will bring this proposal as conditioned into compliance with the city's regulations. So with that, I've completed my preliminary analysis, and I'd be happy to answer questions later or turn this over to Ms. Howell.
Let's go ahead and proceed with the rest of the city's presentation from Ms. Howell, and then I've got a couple of questions, but I'm not sure who they're going to go to. So, Ms. Howell.
Thank you, Mr. Turner, Eric. Brenda Howell, city engineer for Ridgefield. So the engineering conditions on this are fairly straightforward. Most of the conditions are standard. They have met the majority of our standards as required. There are a couple of variations from that. The primary one in regard to the required trails, there is Trail T18 located, which is a regional trail in the city's capital facilities plan, crosses the property, as well as the city's plan to G Creek Trail improvements are also on the property. The applicant has proposed trails. They have proposed placing the T18, which is required to be a 10-foot or 8 to 10-foot trail within a 20-foot easement. So they are proposing to build the trail as required. However, they want to place it in a 10-foot easement along the southern property line and leave the remaining easement to be dedicated by future development to the south. The city has agreed to this. They will, the remaining trails to the north are in their standard easement sizes in the 20 feet as is required. However, they have requested some areas to not pave the trail. So the city has conditioned them to pave all the trail along the southern border within the reduced easement, and the other segments of trail should be paved as well. However, they may be gravel depending upon the geotechnical considerations and the determination of a geotechnical engineer. Some of the slopes are too steep for paving. So there's that condition, and then the other variation that is addressed by a memo from Hanley regarding the alignment of the street, or rather the lack of alignment with the proposed street from Hillhurst across from South Refuge Road. Normally, we would require that those streets line up. The primary issues preventing that are the limited frontage on Hillhurst that the project has, as well as the Olympic pipeline easement that is actually within the alignment if they were to align with Refuge Road. Additionally, Refuge Road functions more as a driveway than a road. It only serves the city's dog park and the refuge, and any future development is unlikely, but would be required to make significant improvements to that road before it could serve any additional parcels. I'll let Mr. Lee discuss his memo where he analyzed safety issues at the corner. I generally concur that there are no significant safety issues with this alignment. And all the other conditions we have are standard and or can be worked out during engineering.
Okay.
Mr. Examiner, this is Eric Eisman. May I make a point of clarification?
Sure.
Sure. You asked the question about the name of the street that's stubbed to the north. And while Brenda was talking, I just went back online and looked at the county's GIS mapping system, and there is a bit of confusion. The street is named South 8th Way as further to the west, and it's also named South 19th Street as it comes down from the north. In my staff report, I believe I've consistently called it South 19th Street, but I can see why there is some confusion about what it is.
Yeah, because
it's 19th in my mind because it runs north-south, which would be consistent with the names of the other streets in the subdivision that have numeric numbers going north and south.
That makes sense. And there's also a South 9th Way on the south end of the site, which adds to that confusion.
Yes.
Thank you.
You're welcome.
I was just about to ask that question.
Okay.
I just had a couple questions on page 2. It refers to PARS mapping. I don't know that acronym.
I'll take that one. That I believe that would be the FPAR, the Forest Practices Act.
Forest Practices. Okay.
Forest Practices.
Thank you. My circle went through the F and it looked like PARS. On that same page, it says two unnamed, and you in your testimony, there are two unnamed type N tributaries to G Creek and G Creek as well on the site. But the map on the next page appears to show 3 streams, a type U, 2 type U and 1 type N. Can we clarify that issue? Because it's the top left photo on figure 2 on page 3 of your staff report.
Right. I see down at the very lower corner, southeast corner, the unnamed stream. Technically, you are correct. That is outside of any development area, so I omitted it. Yeah.
Thank you. That makes sense, though, that it was excluded. Page 12.
What section?
I'm looking. I had to get to my page. Right above E, that last bullet, it refers to the conditions prior to final plat approval, provide a map of dedication showing all land dedicated to the public for purposes of whatever, and all easement rights dedicated for private purposes. Does that include the trails, or are those for?
Yes, it does.
So the trails are private easements, they're not a public access trail?
I can answer that. The trails will be public.
Thank you.
So it should say dedicated for, it is dedicated for private purposes, is that? language correct in that condition?
That is the language from the code. It's a new addition to the city's development regulations.
Okay. If the city's comfortable with that language, that's
Yep.
fine. I just wanted to clarify that. On the next page, under G, landscaping and trees, the last sentence of the first paragraph says the applicant's required to use plants on the native plant list or not use plants on the nuisance or prohibited plant list. Should that say and?
That would make sense. Yes, it's a bit awkward, but I think the intent is there. No nuisance plants, no prohibited plants.
Right.
Please use native plants, so long as they're not nuisance or prohibited.
Cool. On page 14, the first bullet says a 15-foot L1 landscape strip is required along Hillhurst. I thought on page 10 it required a 25-foot landscape strip on Hillhurst.
It is a 25-foot landscape strip.
So is that first bullet is the 15-foot should be changed to 25?
Claire, am I correct on that from my memory?
Eric, I believe so. Along Hillhurst Road, the typical 15-foot buffer is extended to 25 feet.
I believe so.
Okay. And I think that's what the condition language says.
I believe so, yeah.
So I'll fix the condition. Page 18 and 19 were my last ones. Bottom of page 18. Oh, I think Ms. Howell addressed this one. That's the intersection spacing issue. I'll wait to hear what Mr. Lee has to say. So we'll skip that one. The last question is on page 19 after the final bullet, Pioneer Street project, a traffic signal at Pioneer and 9th Avenue was included in the traffic study, but it is not reasonably funded and shouldn't have been included in the traffic analysis. Does that change the conclusion of the analysis?
This is Brenda Howell again. No, I don't believe this changes the conclusion of the analysis.
Okay, thank you.
They're simply being required to contribute toward the construction.
Okay, that was the only questions I had. Mr. Stonex, are you representing the applicant?
Yes, I am. For the record, Kurt Stonex with Olson Engineering, 222 East Evergreen, Vancouver, Washington, 98660. Ingrid Freeberg is here, our project planner, and then also Honley from HC & Associates to answer any questions about traffic. I'll let him speak about his memo when I'm done here. So yeah, we, as in general, we are in agreement with the staff report and conditions as written. I just have a few things to add. I think it's important to point out that this project was designed to avoid all of the critical areas that we possibly could. There's just under 60% of the site has been set aside as open space. The only impacts in any of those critical areas at this point are the trails from the trail plan and then a corner of the underground stormwater facility. I think I'll go ahead and, as far as DOE's comment, so what they had suggested is that we move lot 13 and 14 into tract B and move the pond closer to the street. Well, there's nowhere to put lots 13 and 14 that aren't a geohazard.
Okay, so that's what I missed.
Yeah.
So tract B is a geohazard, so you can't put lots 13 and 14 there.
Yeah, I mean, you can see on the map there's a dashed line that pretty well follows the trail, and the trails actually drop into the geohazard area. And as Brenda indicated, we're going to walk those trail routes with the city during final engineering and figure out which ones we can pave and which ones are going to end up being some more gravel and there may be lesser widths.
Is Mr. Stonex, is tract B in the upper left, the top left corner, the northwest corner of the site?
Well, I was actually referring to tract D, but tract
D
B
is in dog?
Also, yeah, I was D and dog.
Oh, okay.
Is what I was thinking. But
Is
tract B is also a geohazard area, so that there's neither one of those places work.
There's D. D is along the stream,
Yeah.
correct? Okay, yeah,
Yeah.
I don't see how that would work. I thought ecology was referring to B as in boy.
Well, they could have. It's been so
Okay.
long since I responded, but yeah, the reason we haven't put lots there is because of the geotechnical issues.
Okay, I don't see a geohazard line on that tract. It's okay.
We may not have labeled it. It
Okay.
should show up in the geotech report from Columbia West. So I know it shows up on GIS too. I think it's one of the exhibits to the hearing. I thought I saw it in the presentation.
Okay.
Then as far as the setback along, or the landscape strip on Hillhurst, my understanding is it's a 15-foot landscape strip and a 25-foot setback to the building. That's what we're showing on our map. So I think that's what that is, but Claire Thomas-Less
Can I, if I can comment now?
Yeah, please.
Yeah,
Ms. Lust, can you state your name so we know?
This is Claire Lust. Kurt, I just looked that up as well. You are correct. With regard to Mr. Turner, your earlier question about landscaping along Hillhurst, it is a required 15-foot L1 landscape buffer and a 25-foot minimum setback to the building.
Thank you. I thought that's what it was, but I looked back at page 10 and I thought that's what it said, 25-foot landscape. So that clarifies that issue. I appreciate it. Go ahead, Mr. Stonex.
Okay, and then the other thing I wanted to talk about just briefly is the heritage tree. There's a Japanese maple. It's adjacent to the house on the parcel, and our landscape architect has looked at it and he said there's no way that tree is going to survive if we remove the house, which needs to be removed. So we'll end up going to council to get that approved. I think it's
okay.
I think it's a reasonable request, and we can mitigate. We have lots of room to add lots of trees. Let's see. And so I had one question on one of the conditions. It's planning condition 19, and it's on page 26. And it's referring to I'll give you a second to get there.
I think my page numbers are different because I printed the Word copy. Hang on just a second.
It's the first
Condition
one under
19.
19.
Yep.
Prior to final plat approval.
Got it. Yep.
And so the staff report points out which lots can have the reduced street side yard setback. And I believe lot 1 should also fall in that category. The question in the code is lot 1 considered a perimeter lot for the perimeter compatibility measures? Page 12 talks about the compatibility measures. And I think, let me get there. Since that lot is on a public road, it doesn't meet the criteria where the perimeter compatibility would apply, because it's not abutting an adjacent private parcel or another lot. It's up against a road. And I think that meets the standard for not being a perimeter lot. So that's I guess a question I'd like you to look at as you review the record and make your decision.
Okay.
Okay. I think that was all I had, unless I missed some of the questions. Do you have any other questions?
No, just waiting to hear Mr. Lee's response to his summary of his memo about the access spacing.
All right. Now, before he talks, I just staff had questioned that offset and thought there might be an issue, so I'd ask him to prepare that memo, and I'll go ahead and let him speak to it. Thank you.
I don't believe I haven't seen the memo. It might be in my record. I just missed it. And before I forget, the comment letter from a neighbor that staff noted, I did get an email this afternoon with it, but what I got attached to it was the comment letter from Department of Ecology again. So I think I'll ask staff to send that letter again, so I make sure I get the right letter. I can review it.
Yeah, the traffic memo we just submitted about a week ago. Ms. Lust, is it one of the exhibits?
I will review the exhibit list right now and let you know if it has a number in there.
Okay. All right, thank you. Han.
Okay, Mr. Examiner, this is Han Lee with H. Lee Associates, and I'm representing the applicant, PO Box 1849, Vancouver, Washington 98668. And just a quick summary of my July 14th memo regarding the access spacing. We analyzed things both from the safety standpoint as well as the capacity, and we didn't find any things that really concerned us with the spacing issues. We have good sight distance between the intersections. We also, the accident records show very little accidents occurring in this area, and also the low speed. So that in combination with the sight distance reduces any real concern. And also, we were fortunate enough to be able to have the Refuge Road access in our video counts, and so from last year, so we were able to count that intersection before the pandemic, and so we have normal traffic counts there from last year, and there's very, very few vehicles using that road, and so, you know, combined with a good level of service, very few accidents in the area, low accident rates, good sight distance, slow speeds, and we feel that the development access can, and the Refuge Road access can basically operate safely as proposed.
Okay, thank you, Mr. Lee. Is that it from the applicant? I'm sorry, go ahead, Ms. Lust.
Oh, Mr. Turner, the associated exhibit is B as in boy 07.
Thank you. I'm sure it's in there. I just managed to skip over it in the list, I guess. Mr. Stonix, anything else from the applicant at this point?
No, that's all for now. Thank you.
Okay. With that, I'm going to go through the list of people who are attending the hearing and ask if you want to say anything. I'll ask you to unmute your own microphone when I call your name. Lucas Ralston. Do you want to say anything, Mr. Ralston? And you'll need to unmute your microphone to let us know one way or another. And there is a unmute button right in the middle of, at the bottom middle of your screen. If you scroll over it, you should be able to unmute yourself. Okay, we're not getting any response from Mr. Ralston. We'll come back to you, Mr. Ralston. Zach, I don't have a last name. Did you want to testify about this application? And you'll need to unmute yourself. There you go.
Yeah, you can talk. Yep, talk.
Oh, hi, this is Marie Stephenson.
Can you spell your last name, ma'am?
Stephenson.
Thank you.
1170 South Hillhurst Road, Ridgefield, Washington 98642. And my property is just south of the development. And I was concerned because now I see there's a walking trail that will go right down beside my property. But that is going to be public, I understood.
Mm-hmm.
And it was going to be paved?
Yes.
Okay. And what kind of fence are they putting up between the walking trail and the property on my side.
I'll ask the applicant to address that in staff.
And also up in the corner of Hillhurst Road,
Got map.
there's a big fir tree that's right by Hillhurst Road.
Right by number 2.
And it would be at the beginning of lot number 2, I think.
And the walking trail.
And the walking trail, it's right where the property comes out on Hillhurst. And that is a tree there that is a property marker. Would that stay? Would that have to be removed, or what you intend to do with that?
I will ask the applicant to address that. I don't know what their plan is, so we'll ask them.
What?
The property markers, that had a question.
The what?
I don't remember.
That was my main concern. And then if the hearing's going to be open for a week, if I come up with more, I can write to you.
Yes, ma'am.
Okay, that's my question then.
Okay, thank you, ma'am.
Thank you.
I just have a phone number and I only have 3, and the first number is 3 and the last are 79. Everything else is blotted out on my screen. Hopefully somebody recognizes that phone number.
Mr. Examiner, that's mine, Kurt Stonex.
Okay, thank you. Yep,
right.
I figured. The last one is, again, a phone number, 8, and the last 2 digits are 98.
No, sir, I don't have any comments. This is Ingrid Friedberg.
Great,
with
thank you,
Olson
ma'am.
Engineering.
Okay. Mr. Eisman or Ms. Howell, anything you want to add, or Ms. Lust?
I don't have anything further, Joe or Mr. Turner. Thank you.
Okay.
Brenda, there was a question regarding the fencing for the Southern Trail.
I'll let the applicant.
Oh, thank you. You're right.
I will let the applicant answer that.
You're right. I have nothing else to add then.
Okay. Mr.
I have
Stonex.
nothing else either.
Sorry, Ms. Lust. Thank you. Mr. Stonex?
Mr. Stonex, for the record, I haven't actually spoke with the applicant about what kind of fencing. I guess with the open record, we could probably let her know here in the next day.
Okay.
And then we could somehow get that into the record before the record closes. And the same comment on the tree, when the survey was done, we didn't map the trees along that south line, so I don't know exactly where that tree falls, but that's something else I'll try to figure out in the next week. Or if nothing else, we can get it in the second week.
The city code does not protect trees beyond the heritage tree, is that correct?
This is Eric Eisman.
Yeah.
Sorry. In response to your question about tree protection, the city code protects trees on the heritage tree register and those trees that are within critical areas and critical area buffers, but does not necessarily address this type of tree along the frontage here.
Okay. Yeah, I forgot about the critical areas, but
I would just also mention that a critical tree is a white Oregon white oak tree, but I do not believe that that's what this is. The applicant would know.
I thought Ms. Stephenson said it was a fir.
Okay. I missed that.
I believe so. Mr. Stonex, I think Ms. Stephenson said that tree was a boundary tree as well. It's my understanding in the past that trees were sometimes used as property boundary markers. I'm assuming that has been replaced or will be replaced with the final survey with an iron marker if that tree were removed. Is that correct?
Yeah, we would need to do that.
Okay.
But typically, if a tree falls on a property line, the tree's going to stay. We'll work around it unless there's a mutual agreement from the property owners to remove it.
Okay. Ms. Stevenson, since you had some questions, the applicant has responded. I want to give you a chance if you had any follow-up questions after they've testified. As far as the fence, the applicant's going to address that, and I'll ask the applicant to address that in the next day or 2 days at most. So you have a chance to respond if you want to during the open record period to their response to that issue.
That's fine.
Okay. So you don't want to add any, you don't have any other follow-up questions at this point?
No,
Thank you, ma'am.
thank you.
Mr. Stonex, I'll give you the final word just in case if you had anything you wanted to add before I close the hearing.
I don't think so. Thank you.
Okay. With that, I will close the hearing. I will hold the record open, as I noted, for 1 week until, can't see my calendar from here, the 28th of July for the public to submit any additional testimony and evidence. Mr. Stonex, I'll ask if you can to respond to the 2 issues regarding the fence and the tree within the next few days, so the public can respond to your response if it raises any additional questions. I will hold it open for an additional week until, I guess we're into August, aren't we? And I really can't see that one. The August 4th. For the applicant's final argument and response to any issues raised during the first week. If the applicant chooses, you can waive that or reduce that second week by submitting something in writing to the city saying close the record. That response can include your final argument if you wish, or you can just include a statement, but just I'll close the record when the applicant directs me to, or on August 4th. Mr. Eisman and Ms. Lust, is it 5 o'clock? Does anything have to be received by the city by 5 o'clock, or do you have an earlier deadline?
5 o'clock is adequate, yes.
Okay. So anything anybody wants to submit from the public has to be physically received by the city by 5 o'clock on July 28th. The applicant's final argument must be received by 5 o'clock on August 4th. I will try to get my decision out by August 18th. I will send my decision to the city. The city will send it to parties of record. So if you've testified orally or in writing, or you provide your name and mailing address to the city, you'll be sure and receive a copy of or notice my decision when it's issued. But that concludes our hearing. Thank you all for your participation. And this is our second hearing with no technical issues. So congratulations.
All right.
Thank you very much. You guys have a good night.
Good night, everybody.
Thank you.
Thank you.
Thank you. Good night.
Good night.